Wagwajaga, Ejagajaga, Wajashon. Wagwajaga, Ejagajaga, Wajashon. Wagwajaga, Ejagajaga, Wajashon. Kaja Israel, Kaba Egypt, Kaja Ethiopia, Kaja Sudan, Wajashon. Kaja Ikushima, you know, Wanime Kona, me Wajashon. So Timbuktu, Ghana, Mali, Sumanguru, you know what you're shown. Wagwajaga, Ejagajaga, what you're shown. So Timbuktu, Ghana, Mali, Sumanguru, you know what you're shown. Manchetaki, you know Sumanguru, you know Wagwajaga. Wagwajaga, what you're shown. What's that to do, you know? Wamasa, you know. Yasantwa, you know what you're shown. Kaja Israel, Kaba Egypt, Kaja Ethiopia, Kaja Sudan, what you're shown. Akwakaba, Chuma, one year, Afo, Karacha, Akachuma, 1 year, Anunyam Feng. Akwakaba, Chuma, 1 year, Afo, Karacha, Akachuma, 1 year, Anunyam Feng. Ameka minyamatu, ameka onyangotu, ameka wanyangwatumo. Ameka minyamatu, ameka onyangotu, ameka wanyangwatumo.
Spiritual.
Some trust in chariots.
America krania COVID-19 yare kodie wo ti atese no. Ye nuanom Ghana fo bebre na won ho ka mu. Na onyame asam say won na wo su no ene won nsu. Enti ebra so say ye kai ye nuanom yi. Beloved, the Committee for the Celebration of the COVID-19 Victims in the Ghanaian Community, in conjunction with Reconciliation International, invite you to the Ghanaian Community COVID Memorial Service in honor of our brothers and sisters who passed away in the Ghanaian community during the pandemic.
Na Serge Medie Kesie yi bekoso Sunday the 29th of May 2022. Ewo Broadwater Farms Community Center, Adams Road, London, N17 6HE. Nearest tube station, 7 Sisters, Bruce Grove, 10 Park Lane. Passes to the venue are W4, 243 and 123. Na Ebrenin so yebesha asie 4 p.m. ekosi enumre 10 p.m. pepepe.
This is a time to remember the departed, celebrate their lives, and support the bereaved families. There will be music, cultural performances, recitals, socialization, and counseling.
Nisa enti na yetu yensa ediafre obi biara se mumfa odo embebo odo imu na yenka yenuanom a omotoye COVID-19 ebremu enti se wonnim odofo bi onua bi a otoye a bomodin ne freyen na yemfa no enka dwumadie hu ewo numbers wey so 078 5256 8831 anase 0744 608-1838.
Remember, it's the Ghanaian Community COVID Memorial Service in honor of those who passed away in the Ghanaian community during the pandemic. On Sunday, the 29th of May 2022, Bank Holiday Weekend, Broadwater Farm Community Center, 4 p.m. to 10 p.m.
This program is supported by Ghana High Commission, T. Crip and Sons Funeral Home, National Council of Ghana Union, Ghanaian Churches, Ghana Muslim Council, Ghana Christian Council, Ghana Union, our traditional chiefs and queen mothers, and Omega House.
Media partners: John 4 Crew, Hot Digital Online, A-Class Photography, Abnas Campaign Outreach, and Omega Live TV. Yeda sponsors Nasi, na Jumedie also person obeboa, the patro fre 07852 568 831.
Ghana for Woyonko Daniel Da, Entimayenshia 29th May. Ewo Broadwater Farm.
The Ghana Society UK, Ghana Union UK, in collaboration with the National Commission on Culture Ghana, Reconciliation International UK, and supported by the Ghana High Commission UK, presents a special edition of the 65th Ghana Independence Anniversary Traditional Durbar of Chiefs and Queens. The date is Saturday, 28 May 2022 at the Broadwater Farm Community Centre, Adams Road, London, N17 6HE. The time 6 p.m. to 12 midnight. The Royal Unity Durbar from 5 p.m. Amazing traditional performances, choral songs, traditional poetry, acrobatic displays, African saxo jazz, and special highlights including Ghana Food and Drinks Bazaar, Taste Ghana Chocolate, and many more. For more information, contact 079 399 21151 or the Ghana National Commission on Culture office. Email the Ghana Society at live.com. This event is proudly brought to you by the Ghana Society UK, Ghana Union UK, and supported by the Ghana High Commission UK. It is the 65th Ghana Independence Anniversary. Don't miss this special edition of the Royal Unity Durbar. Sponsors: Tap Tap Send and Diasporan Insurance.
If I didn't have diaspora, I wouldn't have gone to bury my daughter because I couldn't afford it.
When my father passed away, without them, I don't know where I could have started with all the things I covered for the funeral.
Financially, they were ready to give me the money for the funeral here in the UK, or even in Zimbabwe. They were ready to give me US dollars.
Now we looked at other costs, but we knew that at least she was going to be repatriated.
Yes.
There was enough money to repatriate her.
We wouldn't have made it without diaspora funeral cash plan.
Tap, tap, and send. It's okay. Go. Let me speak to my people. Now, let me speak to you. I know the stress people go through when they want to send money from abroad to their family members and loved ones in Ghana and even Africa. See, if you are in the USA, if you are in London, UK, Canada, Europe, any part of the world, see, Tap Send has made it very easy. All you have to do is to tap and send. Within a twinkle of an eye, your money will be sent with no stress. It's very fast, convenient, and easy to access everywhere. What are you waiting for? Just tap, and send.
Download Tap Send now on Google Play and App Store. Tap Send. It's secure, convenient, easy, and fast.
Good evening. Welcome to this evening's edition of the Ghanaian Community Awareness Forum. My name is Emmanuel Kwesi, the chairman of Ghana Union. We are here tonight for an important topic, and we have an expert on the field who will help us to understand the new issues that has been brought to our attention as a community and as a country as a whole, especially with the legal background or the legal context of marriage, the no-fault divorce. This event is put together by the help of Ghana Union, the Ghana Nurses Association UK, the Ghanaian Nightingale Association UK, and the Western Region Association of Nurses UK. We are grateful for the support and sponsorship by TapTapSend, IT Consortium, and Diaspora Insurance. Please visit their website and make use of them. They are the reason why we are able to continue sending you this vital information of community awareness, education, and information right at your doorstep in the comfort of your home. So that while you're home on a Friday evening, every 2 weeks, you can at least be made aware of some of the issues around the community. I would also want to draw your mind to two key community events that is coming up on the 28th, Deborah of Chiefs, traditional Deborah of Chiefs for enstewed and unskinned chiefs in this country. It will be happening at Broadwater Farm. Search the details. We will give the information again at some point. There's also going to be memorial for pandemic victims on Sunday, the 29th of May. Please take note as a community and let's be there to support. Both events are free of charge. We just need you to be there and support as a community. This evening, we will be doing as we always do, and the experts will be taking us through all the other aspects of the law that talks about the new regulations or the new rules around divorce. We have with us here our special guest for tonight, a lawyer by profession, an expert on the field, a senior partner with BWF Solicitors, who has been through the community himself, understands the issues, meet the community people all the time, and help out wherever his skill allows him to do so. He's not a man with much of introduction because his face is familiar. He belongs to a lot of community initiatives, including the Ghana Diaspora Homecoming Summit, where he chairs as the chair. Tonight, we welcome Bernard Osu, the senior partner of BWF Solicitors, to this forum. Chairman, welcome. You're muted, sir.
Sorry, apologies. It usually happens.
Yes.
Yes, thank you very much, Chairman, for the introduction.
Yes.
And thank you all to my fellow Ghanaians, and thank you for joining us. It's very important that at such events we try and help the community with the legal positions, especially because most of us were not born in this country. It's always important to understand what has changed so that we don't make mistakes which could be costly. First of all, the topic for today is, we're going to look at the new divorce law, and the formal name is DDSA, which is the Divorce Dissolution Separation Act of 2020. So the formal name is DDSA, the full name is Divorce Dissolution and Separation Act of 2020. Although it says 2020, it came into effect on the 6th of April of 2022. Many people have said it's a groundbreaking change. It is fundamental to many people. I'm sure you would have read in the news or seen on the TV, a woman who wanted to divorce his husband of about 40 years, where the court said, unfortunately, you can't. You have to stay married to him because you've not been able to prove one of the 5 factors that you have to prove under the law. So prior to 6th of April 2022, we had a Section 1(2) of the Matrimonial Causes Act of 1973, which basically says that if you want divorce, you need to apportion blame. It was as simple as that. And many people thought that it wasn't good. It brought a bit of animosity between couples. And clearly where there were children or financial matters to be resolved, it made it potentially very, very difficult for this to be done. Therefore, there were a lot of agitation and reports, many articles written by judges and lawyers and even community leaders that the law ought to change. So this law has been long in coming because of the particular aspect of our lives that divorce involves. I mean, about 4 marriages out of 10 breaks down every year in England. And sadly, it happens in all communities. The latest statistics says that, in the first 5 years, you're potentially likely to break down than in the last 5 years of your marriage. So it's something that we all have to take cognizance of. What I also want people to recognize is that divorce itself is a means. It's not the end. It's a process. And I've seen many people pass comment when our sister in Nigeria was alleged to have been harmed by her husband, and she passed away because of potentially his negligence or something of that sort. So, but as a Christian, we are very cautious when we're talking about divorce. First of all, this divorce law does not apportion blame. So you can issue divorce on the simple proviso that you will confirm that your marriage is broken down irretrievably. The concept of irretrievability is from the old law as well, because under the old law, there was only one grounds for divorce, which is that the marriage is broken down, and that will be supported by 5 factors. So either adultery, unreasonable behavior, desertion, 2-year separation, or 5-year separation. But with the current law, all you need to say is that my marriage is broken down irretrievably. The terminology has also changed. So whereas we had a divorce petition in the old style, now we have a divorce application. In the old style, the person who starts the application was called a petitioner, is now called the applicant. Although the person who receives the application is still called a respondent. Old style was called respondent, they are still called respondent. The other key terminology that has changed is that you all know that when you file for divorce, there is an interim order that you get, which is the half divorce that they give you. And that's the divorce nisi or divorce nasa, which is the initial divorce that they give you. That now is called a conditional order. And then the decree absolute that we all know, or some of you will know, because maybe you know people who've gone through divorce, is now called the final order. So no longer do we have decree absolute or decree nasa or a petitioner. We have an applicant, a conditional order, and also a final order. Now, people will want to know what is the process. So the first of all, you don't have to have a lawyer to issue a divorce application. Divorce application can only be issued after 12 months of marriage, unless certain circumstances, very restricted circumstances, that you can bring nullity proceedings if you haven't done the 1 year. So the first process is to determine whether this is for you, okay? Divorce is not taken lightly. Usually we advise people to go for counseling to either relate or some other relationship charity where you can sit down and have a tete-a-tete with your partner, where you can be candid with each other and hopefully resolve issues and move on. But clearly, if it doesn't work and you want to proceed with divorce, then you can either do it online or you can use a form called Form D8, which is a divorce application form. So you issue the application, and another new change that has come is the process of service. So under the Family Proceedings Rules, 2010, they've amended the rules, whereas under the old style, you could only serve divorce petition by physically posting it or having a personal service on the respondent. Now, it can be sent by email. So your application can be sent by email. The court have emphasized within the family law proceedings rules that it will be their ordinary email. Now, I put emphasis on the word ordinary email because if you're like me, you have two emails. You have your private email and you have your official work email. Under no circumstances can you serve the divorce application on his work email. That is frowned upon. It's the same thing that we had with the Old Star where you couldn't go and serve him. Maybe if the person is avoiding service and you know where he works, you know he works there, but you can't go and serve him. It's the same way that is a work email, you cannot serve him. So even if the service is done by email, the court will still write to an address, a physical address, just to confirm that a service has been made. Under the Old Star, the limit to respond, there was no limit to serve the petition. It could be served anytime. But under the current dispensation, once the application has been issued, you have 28 days to serve it. Now, it brings a lot of difficulties for people. I'm aware that there might be instances where the respondent may be avoiding service. Because there's no blame, he wouldn't have a defense. And I will come to defense later. So the only defense he will have is to run away from service. And once he's become aware that divorce has been sent by email, he may try and avoid it because, if he doesn't file the acknowledgement of service form, then there will be no confirmation that he's received the divorce application. And unfortunately, it means that you may be compelled to fill a Form D11 for personal service on him, either by the court using the court process service or having your own process server, either using a bailiff or somebody else to go and serve him. So that brings in the responses that one can put in. Under the Old Star, you can say, no, I haven't behaved that way. I haven't behaved irresponsibly. I have not been unreasonable. I have been a true husband or a true wife. It's just a mere disagreement and the marriage is not broken down irretrievably. Under the Old Star, you could defend it. So you could file a defense and an answer. Under the current dispensation, there's no grounds for challenge. So if I say the marriage is broken down irretrievably, you cannot say, no, it's not broken down. And that is where the Christian community is particularly concerned, that this cheapens marriage, because one person can just wake up and decide that he doesn't want the marriage anymore. But I've been in this practice for 30 years. And I think, everybody takes divorce seriously. I haven't come across anybody who undertakes divorce lightly. It may be that they've come to that conclusion after several years of pain. And sadly, in some of these cases, there are children involved. And for people to come to conclusion that the marriage is broken down irretrievably, where there are children involved, it must be particularly heart-wrenching. So I don't believe that the fact that the blame has been taken away will make divorce any lighter for people. It still brings the same pain because that's a dissolution of a marriage, something that we all cherish. And the Bible clearly talk as a Christian, I'm sorry, but I'm a Christian and I'm allowed to say my Christian ethos. The Bible clearly says that, marriage is a good thing. But unfortunately, in certain instances, if the marriage is broken down and the other party doesn't want to be part of it, then you cannot compel the other party to stay. The other new concept that is brought in is that you both can dissolve your marriage. So whereas in the Old Star, under the Old Star, it's only one person who can file, and then you can also cross-petition or just become a respondent. Under the current dispensation, both of you can come together and then file the application. Where both of you come together to file the application, the court fee normally is $593. It is envisaged that one person will pay and the other party will reimburse. However, it comes with its own problems because where you file as joint applicants, it means you must do things together. The only time you can do things on your own is if you come to where you're applying for the conditional order. Within this process, once the application has been issued, and then the respondent has completed the acknowledgement of service and returned it to the court, either by email, online, or on paper, there is a waiting gap of 20 weeks. Now, this waiting gap was brought in intentionally to serve as a reflective period to enable parties and couples to reflect as to whether they really want to go ahead with this very, very painful process. So it was brought in, we don't have that under the old style, but under the new style, we have the waiting period, and it's intentionally to force the parties to reflect on what they're doing. So once the 20-week period is passed from the date of application to the 20-week period, you, the applicant, can then make an application for a final order, for a conditional order. That is the only time you can make an application for a conditional order. So the conditional order is a simple confirmation that everything you've said on the application is the truth, and that you confirm that the marriage is broken down irretrievably. The court will then receive it, and then if the court is satisfied that indeed it's got jurisdiction, and I'll come to jurisdiction, and that there's marriage, and that the marriage is valid, and that there's no fraud, and then the court will then serve you with a letter and notice, and just indicate when the conditional order will be made. This will be served to both parties. Once the date of the conditional order comes, it is just an administrative process. The judge will sit in court. You don't have to go. The respondent doesn't have to go. The applicant doesn't have to go. If you go, nobody's going to listen to you. The judge will then have a list, maybe about 100 people who are dissolving their marriage that day, and call Equiata versus Yaumenu, and then go through the list. Once that is done, you get a conditional order sent to you by email, and a very simple form, which is sent to you by email. Once you've got that, and you still want to go ahead to finalize the process, you have to wait for 6 weeks. So as you can see, from the beginning to the end, if everything goes smoothly, and they don't go smoothly, that I can tell you, you're looking about 26 weeks. Divorce typically would take better part of 6 to 8 months. Divorce typically, under the old style. Under the new style, I'm beginning to think that it might even be longer because of the wait, because there was no wait before. Now there is wait. And also, there are delays at the court. So although the law says that from application to the next application is 20 weeks wait, it may be that once you put in the application, you don't hear anything for another 5 or 6 weeks. Although after the wait, you still have to wait for another 6 weeks. So in effect, you may be looking longer than 6 months. But why do I think that this may take away some of the pain, of the hurt, of the animosity? Because there's no blame apportioned. My experience is that people don't generally accept blame, and that if a wife says that the husband has been unreasonable, the husband usually wants to respond and say, no, I haven't been unreasonable. Because within the old style, just bear in mind that once the divorce happens, or once the process is started, one party can also commence the financial settlement or financial matters to be settled by the court. Now, a bit of advice to everyone. Now, if you still want to go ahead with your divorce, just be careful. Once you've got a conditional order, I'll ask you to pause and then resolve your financial matters. It may be you own a property together. It may be the man owns a property on his own, but it was purchased during the marriage, but it's got his sole name. It may be that you joined the man in the UK and that when you came, he had his own property, but It's a long marriage, so the law says that you're entitled to something. Because the problem is that once you file for the final order and the other party marries, you cannot make an application under the Matrimonial Causes Act for a share of the property. You can make or you may make an application under TOLATA, which is the Trustees and Administration Act, but you cannot make an application under the Matrimonial Causes Act of 1973. The difference between the two applications is that such applications are simpler under the 73 Act, but they are a bit more difficult under the Trustees Act because then you may have to show contribution. It may be your contribution was physical money. It may be your contribution was just buying food or paying bills. But either way, you will have to prove because the burden of proof will be under you. Whereas under the Matrimonial Causes Act, it's a bit easy. The court will go through the usual things that they have to look at for need and fairness and equity. But under the Trustees Act, you will have to show contribution. Now, how do you do this? To do this, you go on the HMST, so the Her Majesty Tribunals and Court Services. You go on the website and you find a divorce. There's the two portals. You need to find the one for divorce. And then you fill the forms. The court fee is $593. So you fill the forms, and then that goes by email. You get an acknowledgement. You can print a copy of the form, and then you keep. The court will then write to you to say, we've now analyzed your forms, it's valid, and then we're going to go ahead with the process. The other person is served with an email and then also by post. So you must know their email, and you must know their effective email and also their residential address. This is key. Once the process is done, you've got your final order. Just be mindful that divorce affects inheritance and it may affect a will. Because I remember a case that I did about 20 years ago. A former police chief inspector who schooled in the UK, and he wrote a will. And in the will, he wrote to my wife, I give everything I have to my wife, and blah, blah, blah. He separated from this woman for 20 years, went to Ghana, married, had a stable family. At the age of 75, he passed. So when the will was read to my wife, of course, to my wife, he hasn't divorced the wife in the UK. So to my wife means the wife in the UK, a woman that he hasn't had anything to do with for the past 20 years. And these are some of the things that we have to be mindful. Just be mindful that in your will, if you've mentioned anything or you've given a legacy to your wife or to your husband, the divorce will sever this. Because when you say to my wife, it's no longer your wife, because at the time that you died, he or she won't be your husband or the wife. The other thing that I want to advise people on is that if you're having problems with service, then you need to engage a lawyer because it becomes very technical. Yes, you can use a Form D11 to make an application, but because of the deadlines, under the current STAR, you need to serve within 28 days. You can apply for extension, but the court will ask you to prove that you've made every effort to serve, either using the court or using a process server to serve. It is only on that basis that the court will give you extension. So although people think that this might be easy, I beg to differ. That it might be slightly difficult. Yes, the administrative process is straightforward. You sit behind your computer, you just issue, and it goes by email, and you don't have to apportion blame. But in the final analysis, if the respondent is running away from service, then it's going to be extremely difficult for you to prove that you've served them. So I will pause here, and if there are any questions, I'm happy to respond.
Thank you so much. Thank you so much, Bernard. We heard this on the 6th of April. I was on the news here listening, and then there were, Sky News was going on about the new changes that has been in existence. The old law has been there for half a century. Now, when you say all you need to do is to declare unreasonable behavior, what goes into the word unreasonable? Irretrievable breakdown. Sorry, my apologies. To be able to say that, look, the marriage is now broken down irretrievably. Is there anything that you need to go into that word to make it irretrievable, or you just put that word and that's it, no question asked?
Well, if you come to the legal definition of irretrievably broken down, then clearly under the old style, it means that it's now almost impossible for you to patch up.
Right.
Because under the old style, you have to prove that the marriage has broken down irretrievably. For example, if you, under the old style, petition for unreasonable behavior because your husband doesn't sleep at home or doesn't eat your food, which can be some of the grounds, or your husband is very rude and always insulting your parents, but you're living with him as a husband and wife, lying on the same bed, the marriage hasn't broken down irretrievably. But under the current dispensation, because there's no apportion of blame, as a party who says that the marriage, it is in their hand, nobody can question them. You're not asked to prove that the marriage is broken down. All you have to say is that I confirm that the marriage has broken down irretrievably. And that is all you need to say. So there's no legal test under the current dispensation. But under the old dispensation, of course, it means that it's broken down beyond repair.
Right. Audience, please put your hands up. Those watching on Facebook, please send your messages and we will get it read. Use the Zoom icon to raise your hand. Lawyer Bernard is here to answer all the questions. I have a lot of questions that has been sent to me prior to the forum, so I'll be going through. But I think this forum is for you, so put your hand up so that we can get some of these key parts answered. So with this law that has come in, Lawyer Bernard, what will be its implication on families? For instance, families who are being together, let's say a couple being together, they got married. The wife had their own property before they married. There was no attempt by the husband to join the wife's property. The husband has not invested anything here, but rather invested outside the country on his own. And then comes divorce. What happened in that context? Because then there's no children, for instance, there's no children, there's nothing, no attachment to that marriage in its context since it was formed. But then individually, everybody has achieved their own bits in their own corner. What happens?
Well, I mean, first of all, the distribution of assets or financial settlement under the Matrimonial Causes Act hasn't changed. So the concept is the same. The concept is based on needs, fairness, and equality. So when parties marry, anything acquired within the marriage is said to be, there's a word that one of the judges is called marital acquest. So it was acquired within the marriage. However, if somebody brought something into the marriage, or whilst married, he or she acquired something, although in their own name, that also can be considered as marital asset. So let me give you an example. You brought your wife from Ghana, or a wife brought the husband from Ghana in 1992, 30 years ago. When he came, she owned her own 2-bed apartment. He joined her and they've lived there ever since. They've got one, they haven't got any children, but they've lived there for 30 years. Now that's a matrimonial home. So when the relationship breaks down, the court expects equality to play a part. Maybe that the husband will also have to be housed. And in those circumstances, it's very likely that he could ask for the house to be sold or the woman to support him to buy a house. But I say this, it doesn't always follow, because I also refer to the issue of need. For example, if the husband is more than capable to buy his own house without selling the property of the wife, then clearly that will not happen. But I keep telling people that in the scenario that you gave, where one person is investing in Ghana and one person is buying property and the other person doesn't want to know, saying that I'll be going to Ghana, so really I'm not interested. Those are facts that will be considered when it comes to distribution of marital assets. But yes, they can claim what you have here. Even the one that they didn't contribute in, they still can claim. And even the one that they join you in, they still can claim. And you can also claim the one that they have in Ghana. I've seen that somebody's asked a question that, whether the marriage took place in England, Wales, or outside England and Wales. It still doesn't matter. For example, if you're married in Ghana under the customary law, you can still file for divorce here. It's done almost regularly. So it doesn't matter where you're married. The only caveat is that for you to file divorce in England, you should be habitually resident here, or you should be domiciled here. The issue of domicile and habitual residence are legal definitions. So if somebody is domiciled here, very likely that they were born here or have lived here extremely long time and have all their roots here. If somebody is habitually resident here, usually if somebody has lived here for a year or more, he's said to be habitually resident here. And those are the tests. So I did say that there are only 3 grounds that you can challenge the divorce. One is that the court doesn't have jurisdiction. So if you say the court doesn't have jurisdiction, it may be because residential test is not met. It may be you all moved to Ghana 20 years ago. You're still Ghanaians. You've never been British. So although you lived here 20 years ago, you haven't lived here for the past 20 years. So clearly you're not habitually resident here. So in that regard, the divorce can be contested. Or it may be that the marriage has not been consummated. So the marriage has not been consummated because you haven't made love, okay? So the marriage is not, or it may be that, the necessary ingredients of the marriage is not there. And those of us who practice cross-border, both here in Ghana, there are issues with our customary marriage. And I always advise people to be very, very careful when you're contracting customary marriage. For example, a case which I was involved in, and is reported, is a case of Millwood versus Alfonso Brown. I went to the Court of Appeal, and the Jamaican man who went to Ghana with his Ghanaian partner from here, he was a pastor. And when they went to Ghana, as far as the woman was concerned, they were going to marry. As far as the man was concerned, the man thought it was an engagement. The man then argued that the proceedings were conducted in a language that he did not understand. Just remember that within our customary marriage, the 4 ingredients that you have to show includes consent. So if he didn't understand, he couldn't have given his consent. And for that reason, the court found that the purported marriage was not marriage, but it was an engagement. Now, the effect of that was that the woman wanted to claim one of his 20 properties, and she felt let down because the court didn't find in her favor. So these are things that you have to be very mindful of. And those are the grounds that you can challenge under this particular dispensation. So if somebody has an issue with the validity of their marriage, validity can be many, many things. Maybe one party wasn't truly divorced. For example, somebody married in Ghana before coming here, customary marriage, okay? Most Ghanaians think that customary marriage is not a formal marriage under English law. It is. If you look at the case of Apt and Apt or the case of Macab and Macab, it is absolutely valid. So if a man comes here and says, oh, I married a Kiata in Ghana, or it's Ghana, we don't have a document, so I can go and marry Menu here. You married and the Kia Mansa here, she can then file and say, this marriage that you've done is bigamy because you're still married to me. In the same way that, other women can also use it against you. The problem we have with these issues is that sometimes we don't take legal advice. We just jump into things and believe that whatever we've done is valid. For example, you married in Ghana 20 years ago. You're here now. Your marriage is broken down. You still believe that you have to divorce in Ghana. You go to Ghana, you go and do the powdering thing, and then we go our rear. And then once you say we go our rear and everything is done, your family goes to swear statutory declaration to say that the marriage is dissolved. Meanwhile, you're living in England. Under the Family Law Act of 1986, that divorce is not valid. So if you marry another person here, that is one of the grounds that he can challenge you under this new dispensation to say that the marriage is not valid. And those are the reasons how you can challenge the application for divorce.
Right. Okay. So there's one person's hand. I think I saw somebody's hand up. Am I right thinking that somebody's hand is up? Oh, I think they've put them. You probably have answered the question. So I have a question here. Somebody's asking, when will somebody be able to remarry under the new law after the what is it called? The new term is what? Final
order, yeah.
Yes. How long will that person have to wait to get themselves hooked again?
Well, once you've got your final order, it means you're free to marry or remarry if you want to. So there's no time limit. You can marry anytime.
Right. So in circumstances where people have got, in the past, they've got decree nisi.
Yeah.
There's decree nisi and decree absolute.
Yeah.
In the past, people get decree nisi and then they quickly go to somewhere and engage somebody. In this circumstance, in these circumstances, if that was to happen, can the other party who has, let's say for instance, you are in the process, you've got a conditional order, and you don't wait for the final order, and then you start getting involved with another relationship somewhere. If that was to happen, can the other party now go to court and say something else? Or
absolutely not. I mean, divorce usually happens at a time that both parties are involved with other people or one party is involved with another person. If somebody is engaged legally, it doesn't really give a legal benefit. So there's no marriage, there's nothing. If you've got a conditional order, you cannot remarry because you're not free, you're still married until you get a final order. So that really will not affect them.
Right. Okay, I've got John Kutin's hand up. John, if you're here, if we can get your question through, we will take a few minute break. Then we will come back to more other questions. I encourage all audience who have questions to raise your hands or send it to the chat room. This is our time to ask all those burning questions. Divorce is painful. We're not doing this to encourage anybody. We are just making you aware of the new rules to guide your lines of thought and other things. People commit suicide, people die out of it, and we don't want any member of our community to become a victim if you are in that situation. So we are here to educate, inform, and make you aware. John, if you're still with us, please ask your question.
Yes, sir. Good evening, and good evening to Mr. Bernard and all the listeners on here. As a Ghanaian, I know that we do have a traditional culture where some people can marry more than one wives. Living in England, it's the opposite around, where you have like one system of just marriage. When you marry one, you can't marry another one. In the case of someone who has married in Ghana traditionally, and comes here and marry another one, what happens in that circumstance? I do not know if this law has taken into consideration that there are monogamous marriages. And even today, I know because of that, people don't want to get married, especially in England. People say my partner, and they have so many partners and they never get married because they don't want to get in confrontation with the law. And at the end of the day, one person will say, oh, you have fooled me into staying with you for a long time, blah, blah, blah. Has that been taken into consideration in this new law, or is just something that has not been tackled at all? Thank you very much.
So the new law, as the name says, DDSA, which is the Divorce, Dissolution, Separation Act, refers to marriage between heterosexual couples and dissolution under the Partnership Act of 2004, and also separation. First of all, under English law, when I say English law, it refers to both England and Wales, because Scottish law sometimes are different from England and Wales. public policy only allows one man, one wife. So you cannot have more than one wife. And the British law takes cognizance of the fact that there might be certain cultures where people may marry more than one person, but the law allows you to only bring one person, and that's for the rest of your life. If you're married to 2 or 3 people, once one person is still your wife, you cannot bring the other person. The law doesn't recognize our matrimonial, potentially polygamous marriages. The law doesn't recognize it. And therefore, if you're married under customary law, you cannot say, if I come here, because my customary law allows me to maybe marry another woman. If I marry here, I'm only marrying another woman, so that's okay. No, that will be bigamous, and it's actionable in court. In fact, I represented a major in 1996. We went to Barking police station, and when he came from Ghana, I had a customary law wife, and I think he forgot. And when he got here, he married an English woman, and they got to know. I think he was in the military. He was a major. And, you know, I mean, he got a slap on the wrist, but it's very serious that you could be in prison if you're not careful.
Right. Thank you very much. We'll take a few seconds break. We'll come back to more questions. Please do raise your hands and we will be calling you in order for your questions to be answered. Thank you.
If I didn't have diaspora, I wouldn't have gone to bury my daughter because I couldn't afford it.
When my father passed away, without them, I don't know where I could have started with all the things I covered for the funeral.
Financially, they were ready to give me the money for the funeral here in the UK, or even in Zimbabwe. They were ready to give me US dollars.
Now we looked at other costs, but we knew that at least she was going to be repatriated.
Yes.
There was enough money to repatriate her.
We wouldn't have made it without diaspora funeral cash plan.
Tap, tap, and stand. It's okay. Go. Let me speak to my people. Now, let let me speak to you. I know the stress people go through when they want to send money from abroad to their family members and loved ones in Ghana and even in Africa. See, if you are in the USA, if you are in London, UK, Canada, Europe, any part of the world, see, Tap Send has made it very easy. All you have to do is to tap and send. Within a twinkle of an eye, your money will be sent with no stress. It's very fast, convenient, and easy to access everywhere. What are you waiting for? Just tap and send.
Download Tap Send now on Google Play and App Store. Tap Send. It's secure, convenient, easy, and fast.
Welcome back to the forum. We want to thank Ghana Nurses Association UK, the Western Region Association UK, the Nightingale Ghanaian Nurses Association UK, the Ghana Union, of course, for putting these ideas together and bringing every 2 weeks information that we also need. We want to thank the Ghana High Commission for their endorsement. Tap Send, your #1 money transfer company to Ghana, IT Consortium. If you have any IT security information, anything that you want to do from a small business to individual perspective, they are there to help you. Diaspora Insurance, Cash Plan. We all have commitment in Ghana, here and in Ghana. Families depend on us. Let's not wait until the phone call comes. Get in touch. They will have various plans that will help us in that time of need. They have cash plans, they've got life insurance and other things. So visit their website and search for the information and give them a call. At this point, I want to thank Bernard for being here. He's a man of immense intellect, well-studied, well-learned, tested in court and various aspects. He knows the law. He's been through it for the past 30 years, spent the time and studied and has supported the community. Bernard is a senior partner in BW of Solicitors next to Seven Sisters Station on Victoria Line. Seven Sisters Station on Victoria Line. When you come out of the station, just around the corner. He's there and his team are there to help. They've been doing so for Ghanaian community. So Bernard, thank you. We continue to utilize your knowledge and expertise in various aspects. And always, anytime we've called you, you've made time for us. We have been talking about divorce, the no-fault divorce, the new law that has come into being. There are questions and answers that we are going through. At this point, I have one question here that I want to ask. Somebody is saying, if you had previously made an application which was going through the process, let's say prior to April 22, can you stop it or can you swap into the new into the new process and make it more quicker? Because some takes a long time, and the anxiety, the stress builds up.
Well, at any point in time, you can withdraw your divorce application. So once the divorce has been served, you have to make an application for permission to withdraw. But once your application has been issued or petition was issued under the old style before the 6th of April, it will continue under the old style, which means that it has to be blamed. You need one, usually the petitioner will have to blame the respondent. But if you're having difficulties, of course, you can withdraw. You can withdraw and make an application to withdraw and then reissue under the new process. You don't send your original marriage certificate, you scan and upload, and it has to be a copy of the original that you're uploading. I don't mean the copy that you've taken with your phone. When it's a copy from the original, they can tell. I don't know how they're able to tell, but they can tell. So just make sure that it's a copy from the original. The other question that someone is asked is, what about Ghana divorce, which is not being accepted in the UK due to domicile status? Woman, Ghanaian, and man is dual citizen. I'm not sure. Okay. So first of all, I don't think Ghanaian divorce is not being accepted. I haven't seen anywhere where Ghanaian divorce is not being accepted. However, if you're habitually resident in the UK, and as far as the Family Law Act is concerned, it's 12 months. So if you've lived here for 12 months, then your divorce from Ghana or from any other country must be a court process divorce, not an other than court process. Let me explain. If you take our traditional process, you can have a divorce without going to court. So family heads meet, allegations are made, dowry is returned, and then the goo powder or whatever is done, and that's it. Under Ghanaian law, that is our law. But if you're living in England and you've lived here for at least 12 months and you are a party to these proceedings, which is the non-court process, it's not valid in the UK. And that's very clear. Many people have fallen foul of this particular route, and where they've gone to marriage registry to book their marriages, that's when they've been told that no, we're not accepting this. However, if you can show that you're not domiciled in England or not habitually resident here, then you can still use a customary divorce as evidence of your divorce in the UK or in England and Wales. But whatever you're doing, please always seek legal advice. Because when I say court process, I've seen instances where people have used statutory declaration because at the top it says in the High Court of Judicature, Ghana, and is signed by the Judicial Secretary. They think that is a court order. That is not a court order. The only Ghana court divorce will say divorce certificate. It will say divorce certificate, not confirmation of dissolution, because if it's confirmation, it means that dissolution took place outside court and they went to court to confirm. Ghana, all this is valid. But in the UK, if you're habitually resident here, which is that you've lived here for 12 months or more, you cannot use this as evidence of your divorce.
Okay, so on that question, where you just left off, if the marriage was a traditional marriage, has been acknowledged by UK, and you, whatever purpose you've managed to live, and you are now returning the dowry and everything else, there's no court involved in that. So how do you attest that divorce if you want to, basically? I don't know if I've explained it well, but
you have.
Do the family members need to sign a document to say that you brought their dowry back and therefore they have accepted it and you're free, or what is the process with
yes,
that?
Yes, the PNDC law 1112, which is now the Marriage Act from 1827 to I think 2000. Basically what it says is that if a marriage is dissolved at home, if you want the evidence, parties will have to swear a statutory declaration, and then it will be taken to the Metropolitan Authority or the District Authority, that TMA, KMA, whatever. And then once you've issued a statutory declaration, they will give you an annex to the PNDC law, which is the evidence of divorce. If you look at a customary marriage certificate, the back of it is a divorce certificate. So they will complete the back of it, and that is the evidence. The statutory declaration is also there. Just remember that Ghana, most of our laws are purely cultural and precedent-based. So even if you don't have physical evidence as paper, if you can have witnesses, there's a recent case that came before me where I had to advise the High Court here in relation to parties who are alleged to have dissolved their marriage in Ghana. There's one that Charlotte also did as well, Charlotte Boyton, and I think that case is reported online. But in all those cases, then you need to provide some evidence of the dissolution. You can't just say that my marriage is dissolved. If you want to use it here, you have to provide evidence of the dissolution.
Right. Okay. With the new law, it says the applicant has to serve notice, and the respondent needs to send acknowledgement. What about if they don't send the acknowledgement?
Yes, and then it becomes so under this process and the old process, there's evidence-based proceedings. So if you say the court will post it, the court will email it if you give the court the email, but the court cannot take that as evidence of receipt. But they don't know whether the email is effective or is the person's email, and there's no way that they can confirm that the address that you've given is the person's address. So normally, in such cases where there's a dispute, and you cannot prove that service has been effected, you have to do a personal service. So you make an application to court and use a form called Form D11. And then you fill the forms, and then that goes to the court. The court will then either send you a sealed copy of the application or maybe try and serve it for you. So they will send a process server to go and serve it. But you can also engage your own process server. However, if you've made all attempts, you've taken reasonable steps and you can't find the person, you can make an application for service to be excused. So there are two processes. One is deemed service, and one service can be excused. But you need to provide a lot of evidence. So for deemed service, if maybe the person has got a solicitor, and then the woman has issued a divorce, husband then sent a text to the woman's solicitor and say, hello, BWF solicitors, I'm not going to sign this. I received it, but I won't sign it. That's evidence that he's received it. Right. I've seen instances where parties have said, well, I was there when the letter came in. I saw him opening the letter. That is unacceptable. The court won't accept that. So you need to take steps to have it served, either by an independent person or something that you can confirm that he has been served, or then you can apply to be excused, that you've taken all reasonable steps and you can't find the person.
Okay, thank you. So does the issue of mutual agreement in terms of two of them sitting down, agreeing, how does that apply in the new law? If we both agree and we are not arguing against each other, does this speed up the process from the 20 to 26 weeks, or it still remains the same?
Well, the 20-week delay for the conditional order is always the same. What you could abridge is the 6 weeks that you have to wait between the conditional order and the final order. But the 20-week, it's there. You can always apply for an abridged time. That is possible. Under the old style and under the new style, we did that. So you can do that. It's ideal that where both parties have come to the conclusion that the marriage is broken down irretrievably, especially where there are children involved, that they agree, so they can agree on provisions for financial settlement. So either periodical payment for the wife or the husband, and child maintenance for the children, and maybe settlement of the woman or the man, depending on who is the primary carer of the children. And you can then draft a consent order, because court processes can be very expensive. A typical low money divorce where the parties, all they have is a council flat and they're fighting over the council flat, and maybe they've got a 4-bedroom in Ghana, that could cost anything up to £15,000 on each person. What is the worth of that? I mean, there's sadly, if you have a council house accommodation with your husband or your wife and the marriage breaks down, it's not automatic that one person can have the property. Sometimes the court will have to make an order. It may be by consent. But if both parties say we all want this council flat, then it has to go to a contested hearing, and you will be paying lawyers' fee. You can go and argue your case yourself. I mean, these are factual-based cases, not not legal arguments, but just factual. But it can be very expensive, and it's always good. Every litigation is better to have a negotiated settlement than a full-blown litigation, because it can be very, very expensive.
Right. Will it be fair to say, from your experience, does our culture add to the animosity that goes on when it comes to divorce? Because from my limited experience dealing with other cultures, especially the English, it's pretty quite simple in some circumstances than some of us, the way we carry on. even when there is no reason for that animosity to continue. We tend to almost ignore everybody else that is going to be affected, only about ourselves. It's always me, 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 me. Do you think our culture is a problem here?
Well, I think every relationship breakdown is painful, especially if it's a long-term relationship. Even if you break up with your friend, your bosom friend, that can be painful. Even acquaintances, if you break up with them. A person that you've shared bed with, possibly have children with, unless, of course, the situation is such that parties have basically fallen out, where they both sat and said, you know what, we're just going to move on. It can be painful. It can be painful. So it's not because of the culture, but I think, as you know, in our culture, marriage is revered. It's something that our parents expect all of us to have. And, so if somebody is falling out of that relationship, even if it's an abusive relationship, they still want to protect it because of the stigma that they failed at marriage. But we all also know that clearly if you're unhappy, you can bring on mental health issues and it can affect other things. And clearly children who are brought up in an unhappy home are unlikely to also thrive in future life. And clearly whatever they've seen, if there's issue of violence, and then that will also affect their future relationships. So it's myriad of reasons. It's not because of our culture. It can be painful. I've seen people in our community who fought over marital breakdown. They both put themselves in prison because they both told the court that they both committed criminal offenses in this country. And they didn't mind that they were doing that to each other. And they both went to prison. So it can be very difficult, yeah.
So in the circumstances where one person make an application, marriage has broken down irretrievably, the other one, is there still a room for another person to say it's not? I don't believe it has broken down.
Well, you cannot, under the current law,
yes,
you cannot defend the marriage. So if it says it's broken down irretrievably, you can't. It's not like that case that an old lady went to court crying, she can't get divorced. And the court said, no, go home. They were not giving you divorce. Go, stay married to the man. This one, if you say you don't want the relationship anymore, nobody can stop you.
Right.
Yes, the 20 weeks is for you to go and think about it and reflect. But the other party cannot say, I'm going to stop you. He may try and say, well, the marriage is not valid. How he's going to say that, I have no idea. Or he may want to say that the court hasn't got jurisdiction because we both don't live here. But clearly, he will be found out if that's using that to delay the marriage. Yeah.
I see. In the past, the court has found some ways to get people, as you said earlier, to go for either counseling or some sort of interventions before they come back to affirm whether they want to continue or not. Does this new law also allow other options that the court can make you to follow before you can be granted?
No, there is no requirement for reconciliation. Under the old style, anytime I file divorce, I need to give a certificate that I've advised them about reconciliation and refer them, and they both, and my client is declined. I have to sign that. Under the new dispensation, you don't have to. They don't have to go to mediation. It's not a requirement. Although if there are children cases involved or financial settlement, there's a MAM requirement, which is a mediation, compulsory mediation requirement. Without that, you cannot file any children application or financial settlement application. It's a compulsory mediation. But for the divorce, there's no compulsory mediation there.
Right. So in these circumstances, if there are children, would the children arrangement or custody be part of the divorce before the final order is granted, or will it be granted before you are referred to another court for those arrangements? How does that work now?
Well, every divorce, the court will ask you whether they are children. And if you say they are children, the court will want to know the arrangements you have. And once you've stated the arrangement and there's no dispute, the court will find that they are satisfied with the arrangement for the children. If one party is not satisfied, they can make an application to court, but they have to try mediation first. And if that doesn't work, although there are exceptions to mediation, especially if it's urgent or the other person is not willing to go to mediation or has been indulgent or there's violence or whatever. But yes, the court always asks on the forms what arrangements have been made for the children.
Okay. Somebody's asking in the chat room, what process do you need to follow in the UK if you have already secured confirmation of dissolution in Ghana?
So if you've already dissolved your marriage in Ghana, you've got a marriage certificate. You don't have to do anything in Ghana. Sorry, in the UK. However, if you've got a dissolution, which is not valid in the UK, you can make an application to determine whether you're married and for the court to enforce whatever dissolution has taken place. But normally what we advise people is, because it's not valid here, you issue a fresh application. That is fairly straightforward and less costly than you starting a family law application, which can potentially go to the High Court. And because there are interjurisdictional issues involved and can be very, very expensive.
Right, I see. Let me look at chat room again. Now, both parties are no longer Ghanaian citizens. Can the application be done in Ghana? So I don't know what that person means. Both parties in the process are not Ghanaian citizens. Can the application be done in Ghana? So I don't seem to. If the person can clarify a bit more, that will help me a lot.
But the Ghanaian courts also expects to have reasons why they should have jurisdiction. For example, I've got a case here where the husband obtained divorce in Ghana. The wife is now also going to challenge the divorce and file her own divorce in Ghana. How that can be possible, I don't know. The Ghanaian courts under the Matrimonial Causes Act, because Ghana usually tend to follow the laws in England and Wales. So we also have a Matrimonial Causes Act in Ghana. And that also will allow anybody who is habitually resident in Ghana or domiciled in Ghana. Because domicile, we have two. We have domicile of choice and domicile of birth. Domicile of birth is never lost. So although we all live here, we're still domiciles of Ghana because we obviously have domicile of birth. So there's always a legal argument on that. Domicile of choice, you can say that we're also domiciled here because where your life becomes almost permanent here, it's no longer habitually resident, but it is domicile. And the difference, it's nuanced, but again, one connotes a permanent fixture and the other one might be transient, but it might be transition over a long period of time.
Right. So in that context, can a Ghanaian court divorce, a British marriage couples by application in Ghana instead of here?
If they've got jurisdiction. For example, if I tend to spend some time in Ghana and some time here, and I was born in Ghana, maybe I'm now British, and maybe or somebody who is married to another woman, they were born in Ghana, but they are now British or married to an English person, but the other person is a Ghanaian. He can issue proceedings in Ghana and the courts will accept it, yeah.
Right. Lawyer Bernard, we'll give you a few minutes to take a quick break, water. We have two community events coming up end of this month that we want to make people aware. Please stay through. We have some questions to come and we'll talk about the next event coming up in 2 weeks' time. We will show one or two clips for that event so that you are all aware and you can share and tell your friends and family. As a community, we need to come together to honor this program. So there's one event on the 28th of May, which will be a Durbar of Chiefs. traditionally stewed and skinned chiefs. It's not for anybody who can put something on and say they are chief. It's only purely stewed and skinned chiefs. And there will be a remembrance on the 29th of May for the loved ones we've sadly lost through the pandemic. So we show those clips. Please take note of it. We'll come back.
The Ghana Society UK, Ghana Union UK, in collaboration with the National Commission on Culture Ghana, Reconciliation International UK, and supported by the Ghana High Commission UK, present a special edition of the 65th Ghana Independence Anniversary Traditional Durbar of Chiefs and Queens. The date is Saturday, 28 May 2022 at the Broadwater Farm Community Centre, Adams Road, London, N17 6HE. The time 6 p.m. to 12 midnight. The Royal Unity Durbar from 5 p.m. Amazing traditional performances, choral songs, traditional poetry, acrobatic displays, African saxo jazz, and special highlights including Ghana food and drinks bazaar, Taste Ghana chocolate, and many more. For more information, contact 079 399 21151 or the Ghana National Commission on Culture office. Email the Ghana Society at live.com. This event is proudly brought to you by the Ghana Society UK, Ghana Union UK, and supported by the Ghana High Commission UK. It is the 65th Ghana Independence Anniversary. Don't miss this special edition of the Royal Unity Durbar. Sponsors: Tap Tap Send and Diasporan Insurance.
Some trust in chariots.
America krania COVID-19 yawe kodi ewu ti atese no. Ye nuanom Ghana fo bebre na won ho ka mu. Na onyame asam say won a wo su no eni won nsu. Enti ebra so say ye kai ye nuanom yi. Beloved, the Committee for the Celebration of the COVID-19 Victims in the Ghanaian Community, in conjunction with Reconciliation International, invite you to the Ghanaian Community COVID Memorial Service in honor of our brothers and sisters who passed away in the Ghanaian community during the pandemic.
Na dwumadie kɛseɛ yi bɛkɔ so Sunday the 29th of May 2022 ɛwɔ Broadwater Farms Community Centre, Adams Road, London, N17 6HE. Nearest tube station, Seven Sisters, Bruce Grove, 10 Park Lane. Passes to the venue are W4, 243 and 123. Na ebrane nso yebɛhyɛ aseɛ 4 p.m. ekosi anwummerɛ 10 p.m. pepepe.
This is a time to remember the departed, celebrate their lives, and support the bereaved families. There will be music, cultural performances, recitals, socialization, and counseling.
Nisa enti na yetu yensa edi afre obi biara sɛ momfa ɔdɔ embɛbɔ ɔdɔ yi mu na yenka ye nuanom a ɔmotoye COVID-19 ebremu. Enti sɛ wonnim ɔdɔfo bi onua bi a ɔtoye a bomodin ne frɛ yɛn na yɛmfa no enka dwumadie ho ɛwɔ numbers wei so 078 5256 8831 anase 0744 608-1838.
Remember, it's the Ghanaian Community COVID Memorial Service in honor of those who passed away in the Ghanaian community during the pandemic. On Sunday, the 29th of May 2022, Bank Holiday Weekend, Broadwater Farm Community Center, 4 p.m. to 10 p.m.
This program is supported by Ghana High Commission, T. Crip and Sons Funeral Home, National Council of Ghana Union, Ghanaian Churches, Ghana Muslim Council, Ghana Christian Council, Ghana Union, our traditional chiefs and queen mothers, and Omega House.
Media partners: Jumbo Crew, Hot Digital Online, A-Class Photography, Abnas Campaign Outreach, and Omega Live TV. Yeda sponsors Nasi, na dwumadie also pese obeboa, the pato frɛ 07852 568 831.
Ghana for Woyonko Daniel Da enti ma yenhia 29th May ɛwɔ Broadwater Farm.
Thank you so much, audience, for staying through with us. These two events are coming up end of this month. We are doing a Royal Durbar of Chiefs for stewed and skinned chiefs in this country who are here. Some are coming from Ghana, and Broadwater Farm will be the venue on the 28th from 5 p.m. to 12 midnight. On Sunday, the next day, we will be remembering all those that we were once upon a time friends to, families to, and sadly are no more with us. So please come with family and friends and join us to remember them. Thank you very much. Lawyer Bernard, we are grateful for your service. As I said earlier, you contribute a lot. And I as a union chair, I am grateful that many people who come to you are not left disappointed. Thank you. Somebody has sent me a private message saying, Mr. Kwesi, maybe the lawyer may have said this, but can you ask him to please kindly help me if he can outline the process of the divorce under the new law? And number two, what does the word no fault divorce really mean? And what grounds are there under the new law? I think the person may have come late. I know you've touched on it, but if you can do that for us, please, we will be aiming to close early. As all the audience are so happy, they're not asking any questions. So I think.
Okay. Well, I mean, first of all, the difference between the no fault divorce and the old style is that the old style has fault. It has 3 faults and 2 separation grounds. So adultery, unreasonable behavior, desertion. And then the 2 separation grounds are 2-year separation and 5-year separation. With a no fault divorce, you don't have to show conduct. So once within you are able to conclude that a marriage is broken down irretrievably, then that will be a grounds for divorce. All you need to show is that you've now filed a divorce. The process starts with an online application. If you're representing yourself, then you can use a form called Form D8. If you have a lawyer, lawyers cannot use paper application anymore. It has to be on the Majesty Courts and Tribunal Services website. You fill the divorce, you need to have details of your the respondent. So you will be the applicant, whereas under the old style, you'll be called a petitioner. It's no longer a divorce petition, it's called a divorce application. And once you're satisfied that the marriage is broken down, you fill the forms online. The fee is £593. You complete, fill the forms, provide an email for the respondent and also their physical address. Then the court will email you to say your application has passed the initial assessment. It will then be issued. By issued, it means it will be emailed, and you can only use this ordinary email, not work email, because you're not allowed to serve divorce proceedings at someone's workplace. And once you've used the ordinary email, the court will write to them to alert them that they've been served divorce proceedings by email. They would have received what we call an acknowledgement form. So the acknowledgement form is for them to just say, that they've received it. They then email it back, or if it's a paper, post it back. Once it goes to the court, the parties will have to wait for 20 weeks before the applicant can apply for conditional order. Then, once the conditional order application is made, the court will write to you and set a date for the conditional order to be made. The conditional order will be read in open court. The court will traditionally have a few more cases to yours and just mention the cases in court. And once you don't have to go to court because there's no grounds to contest this based on the grounds for divorce. You can contest it because the marriage wasn't a valid marriage or the court hasn't got jurisdiction. But you cannot contest that somebody wants to divorce you. The date comes, the conditional order is issued. You wait for a further 6 weeks. On the 6 week plus 1 day, you can apply for a final order. It used to be called decree absolute. You apply for the final order, and once you receive the final order, it means you're free to marry. Caveat: if you have any assets to be shared, when you receive the conditional order, you pause there. You then try and reach agreement. I hope even you reach agreement before you even start the divorce process. If the agreement is not reached, then possibly you may consider mediation. If that doesn't work, then you can issue a Form A, which is the application for financial settlement. If there are disputes about children, this is a time to resolve it as well. And then if the court is satisfied, you get what you want. You can apply for your final order. The final order means that you're free from that marriage, yeah.
Thank you. Thank you so much. Our next program, we will be looking at, we are following some channels, lines of inquiry to see if we can talk about a topic that most people will be aware: interstate succession law in Ghana. I'm trying to find a speaker. If Bernard can help, that would be great. Sometimes I want to give you a break as well, so that's probably why I haven't spoken to you about it. But I'm waiting for feedback. But we will put all of that on the WhatsApp platform as who our speaker is. There are a lot of issues about people whose parents have built houses, they've left it behind. There's so many issues. Fathers dying, and then some children popping up from some corner and saying, I'm your dad, and they want to claim as part of the asset, all sorts of things. So we are looking at how we can educate some of us ourselves about this. It's been a law that has been existing. Some people don't know about it. We want to see how we can cover that. So we once we get the right information, I will throw it to Bernard now, but if it's not available, we will find somebody. If not, we will look at another topic.
Well, I'm here. When you talk about the interstate succession law, of course, that goes together with the customary registration law. There's a case that I was involved in. It's a reported case. It's called the Office of the Official Solicitor versus YEMO. YEMO is YEMOH. It's a case that I advised the court about Ghanaian law. And it's a precedent. It's a precedent about multiple marriages. In that case, we started with 2 children. When we finished, we had almost about 25 children. So as you said, children can pop up from anywhere. It's a very funny case. And it's a precedent. It's one of the precedents for multiple marriages and children, because in England, you don't get that. So it's one of the first cases, but it's there, it's reported online. There's a case of the Office of the Official Solicitor versus YEMO. You can all have a look at it and see what the implications are for those people who have multiple children, because they will apply the interstate succession law, which is basically the Ghanaian law in England. So they apply the Ghanaian law in England, and all the children got something.
Yes, thank you. So we will hopefully go into more detail around that topic in 2 weeks' time. But for now, Bernard, what can we say? We are grateful. As always, thankful for your work that you do and being here. This forum has seen you on a number of occasions. The community is grateful. On behalf of my partners, Ghana Union, the Ghana Nurses Association, the Western Region Association of Nurses, the Nightingale Nurses Association, and of course, supported by Ghana High Commission. And our partners in bringing this program, the Tap Tap Send, and of course, Diaspora Insurance and Chango IT Consortium. We thank all the audience, and we thank you specifically for sparing time. Tonight, I think you've been so clear enough that nobody wants to ask a question. So we will spare you the evening for the next half an hour to go and continue and have a good evening. We want to thank Linda, Paul, and Lillian, who are the IT people, bringing you this, coordinating this behind the scene and making it possible. I will not thank myself, but I'm sure somebody will thank me later. Have a good night, have a restful weekend, and look after yourself. Be good, stay safe. Bye.
If I didn't have diaspora, I wouldn't have gone to bury my daughter because I couldn't afford it.
When my father passed away, without them, I don't know where I could have started with all the things I covered for the funeral.
Financially, they were ready to give me the money for the funeral here in the UK, or even in Zimbabwe, they were ready to give me US dollars.
Now we looked at other costs, but we knew that at least she was going to be repatriated.
Yes.
There was enough money to repatriate her.
We wouldn't have made it without diaspora funeral cash plan.
Tap, tap, and send. It's okay. Go. Let me speak to my people. Now, let me speak to you. I know the stress people go through when they want to send money from abroad to their family members and loved ones in Ghana and even in Africa. See, if you are in the USA, if you are in London, UK, Canada, Europe, any part of the world, see, Tap Send has made it very easy. All you have to do is to tap and send. Within a twinkle of an eye, your money will be sent with no stress. It's very fast, convenient, and easy to access everywhere. What are you waiting for? Just tap, and send. Download Tap Send now on Google Play and App Store. Tap Send. It's secure, convenient, easy, and fast.